Well, good afternoon, everybody. I'm Kate O'Regan. I'm the director of the Bonavero Institute of Human Rights at the University of Oxford. And this is the last issue, as it were, of our discussion group for the Hillary term. And we're really delighted to be welcoming our two panelists for today. Our speaker is Dr. Raffaela Kunz, who's a senior research fellow at the Max Planck Institute for Comparative Public Law and International Law at Heidelberg. And she's going to be talking to her paper and her doctoral research, which investigates the role of domestic courts in relation to the jurisprudence of international human rights courts, particularly the two big international regional human rights courts, the European Court of Human Rights and the Inter-American Court of Human Rights. And the paper is entitled From Compliance Partners to Gatekeepers. So we're really delighted to have you, Raffaela, and look forward to hearing what you have to say. And we're equally delighted to welcome Professor Alejandro Chetman from Buenos Aires in Argentina and the Universidad Torquato di Tella. He has written in this field. I know that he has engaged with Raffaela on her thesis arguments. And so we're really delighted to have somebody from Latin America with deep experience of the Inter-American Court to talk about Raffaela's paper. And for myself, as a former domestic court judge tasked in a jurisdiction which requires courts, when interpreting the Constitution, to consider international law, I have a particular interest in the topic and was very taken with Raffaela's paper when I read it in the European Journal of International Law. So a warm welcome to you both, and we look forward very much to hearing what you have to say, Raffaela.
Thank you very much. Thank you very much for the invitation. I'm really honored to be here and to discuss my work with you. And thank you also to Alejandro for engaging with my work. I will now share my screen. Does everything look all right? Perfect. So the paper I would like to discuss with you today relates to the broader background basically of the paper is the debate about backlash against the human rights courts. As we all know, the two human rights courts, so the Inter-American Court of Human Rights and the European Court of Human Rights over the last years have come under quite some pressure. So in Europe, we are all familiar with the debates about possible treaty exits in the UK and in Switzerland. There is the non-execution crisis of certain judgments of the European Court in Russia. As we know, the Copenhagen Declaration also led to a quite critical debate. And also in Latin America, the court is under pressure. Venezuela left the jurisdiction of the court already in 2012. There is serious criticism also in other jurisdictions. And just in 2019, several governments issued a joint declaration in which basically they asked the court to exercise more restraint. So when I did research for my PhD, which engaged with interactions between domestic courts and the two human rights courts, I was actually quite struck by the fact that some of this resistance against the two human rights courts comes from domestic judiciaries. So this seemed to me to be something different than this political backlash that has been discussed a lot. And in my opinion, this difference was not sufficiently kind of reflected in the literature. And that's why I decided to write a paper about this phenomenon of judicial resistance. And maybe let me give you two examples. So the first example is a judgment by the Supreme Court of Argentina, the Fontevecchia judgment from the year 2017. The Supreme Court in Argentina used to be one of the really strong allies of the Inter-American Court. And in this judgment, it basically decided not to follow the Inter-American Court. And it also stated, it changed its jurisprudence and basically stated that judgments of the Inter-American Court now need to kind of respect the fundamental principles of the public order in Argentina. And somehow some comparable judgment is the judgment 49 of the year 2015 by the Italian Constitutional Court. Also, this court used to be quite open towards the European Court of Human Rights. Some have even criticized it for being too open. And then in 2015, it's changed this jurisprudence basically, and it also decided that Italian courts now only have to follow the European Court of Human Rights in case of a consistent jurisprudence. So again, this kind of struck me, and I decided that I wanted to have a closer look at these instances of judicial resistance that seem to me to be something a little bit different from political backlash, to call it that way. The research questions that guided this research were the following. So the broad research question really was how domestic courts deal with the judgments of the human rights courts, and whether there are patterns either when courts follow the human rights courts and when they resist. So one aim of the paper really was a descriptive aim, basically to bring together these different judgments of engagement, basically, and to really draw a picture of this engagement. But then in a separate step, I also wanted to conceptualize and to normatively evaluate basically this engagement between the court. So the aim of this paper is both to offer a contribution to the debate about backlash in the human rights systems, but also to the debate about the role of domestic courts in international law more broadly. The paper follows like a three-step structure. In a first step, I look at the effects of the judgments of the two human rights courts from the perspective of the human rights courts, so from an international perspective. In a second step, then I change the perspective and I look at the effects from the perspective of domestic courts. And then in a third step, basically follows a normative assessment. And in this part, I ask which role domestic courts play at the intersection of legal orders, which role they should play. And I will, in my talk here, I will more or less follow this three-step structure of the paper. So let's now first zoom in at the international perspective, the perspective of the two human rights courts. So the traditional view is that international judgments only address the executive and not directly domestic courts. And both the European Convention and the American Convention have also taken up this traditional view. Basically, they both contain a provision addressing the high contracting parties or the state parties, the Inter-American Convention. And in the Inter-American Convention, there is an exception for the part of the judgment on compensation of damages, which is directly enforceable before domestic courts. But otherwise, basically, the starting point is that both conventions have taken up this more traditional view, this interstate view, basically, of the effects of the judgments. However, over the years, and of course also in the face of the many challenges the two courts have faced, both have dynamically interpreted and further developed the effects also of the judgments. In this sense, they have not only given life to really the convention provisions, but really also to the guarantees on the effects of the judgments. And this development took place both in terms of the scope of the judgments, but also the depth. So in both systems, right now, I think it is fair to say that the judgments, they do not only enjoy a strict inter partes effect, but they have come to enjoy a quasi erga omnes effect. And also both courts really have concretized the duties flowing from the judgments of the human rights courts. And of course, I know this is kind of an oversimplification. I know that there are really big differences also between the two systems. The Inter-American Court chooses what has been termed a maximalist approach. So it has really a very hierarchical view also on its interaction with the domestic order, whereas the European Court follows a much more differential approach. But still, I think the first conclusion really is of this paper that both courts have laid in their jurisprudence the foundations for compliance partnerships with their domestic counterparts. And this then, of course, raises the question how domestic courts react to this development, whether domestic courts accept this invitation from their international counterparts. And the very short answer is yes, they have accepted this invitation, and domestic courts are today important players, important actors in the enforcement of judgments in both jurisprudence. And a broader conclusion also is then that this confirms basically that domestic courts nowadays do really fulfill an important international judicial function. And this also shows that the very dualistic and state-centered view of effects of international judgments has been overcome, at least in the human rights systems. However, at the same time, domestic courts indicate limits to their willingness to follow the human rights courts. And another finding of the paper really is that they increasingly started to do so. Let's now look a little bit closer at these two aspects. So the first aspect, as I have just said, is that domestic courts, they have become important compliance partners of the human rights courts beyond judgments strictly binding their states. So they really also have started to take into account the broader jurisprudence of the two human rights courts. Domestic courts are willing to adjust their own interpretation to the interpretation of the human rights courts. They are also willing to reopen final judicial decisions in their domestic orders. And courts even act as legislators sometimes, in the sense of that they strike down legislation when legislation contradicts the jurisprudence of the human rights courts, or they disapply legislation. However, and really importantly, many courts insist that they do not consider themselves to be strictly bound to follow the human rights court, but rather they use formulations like they take into account the interpretations of the court, they consider the interpretation of the court. So that's a first important difference. In Latin America, I have found some cases where domestic courts basically treat really the Inter-American Court as an almost hierarchically superior court in a strict monist sense, and where they consider themselves to be strictly bound. But the usual case really is that courts insist that they are not strictly bound, that they have a certain leeway for decision. One of the most interesting findings, in my opinion, of this case law study is that in both systems, courts do not use formal criteria when they decide whether or not to follow an international court. So formal criteria, we know them from the application of treaty law, for example, the doctrine of self-executing treaties, where courts have all around the world developed criteria such as the sufficient precision of a treaty provision and other criteria. Here in the interaction with the judgments, I did not find such formal criteria, but what rather seems to be the case is that courts balance really the different and sometimes conflicting interests on a case-by-case basis, basically. And there are certain factors that guide this balancing. And among these factors are the question whether the judgment in case is really, whether it's really a court is really confronted with the enforcement of a judgment, or whether the case at hand is rather about preventing a possible breach of the convention, whether the jurisprudence in the case at hand is a well-established and consistent jurisprudence. Then also the preciseness of judgments plays a role. And importantly, in my opinion, the two most important factors are really the gravity of a human rights violation and the question whether a domestic court is basically the last resort for the individual concerned to enforce a judgment. So in cases of particularly grave human rights violations, for example, when an individual is still serving a unjustified and unconventional prison term, domestic courts are really willing to step in and to enforce judgments, even though maybe the domestic law basically stands in the way. So an important finding here is that despite also important similarities, there are of course differences between the two human rights systems. In both systems, courts seem to use this informal approach, but there are of course also important differences. Alejandra will probably confirm that of course courts in Latin America, they seem to be much more open towards the Inter-American Court than European courts. In Europe, limits have always played a big role. And this confirms also what Sadursky has called strategic partnerships. So the paper also really confirms that courts in Latin America have also used the Inter-American Court to strengthen their own position in the domestic legal system. So Sadursky has used this doctrinal figure in the European context to basically show how Eastern European courts have used the European Court to strengthen their position, but I think this could also be applied basically to the inter-American context. However, on the other hand, domestic courts see themselves also as gatekeepers, basically at the door between international and domestic law. And many courts really insist on the option to not apply international judgments by the Human Rights Court, particularly in two broad clusters, as I found, as I kind of clustered the research. So first of all, domestic courts reserve the option not to follow a human rights judgment that they consider to be simply wrong. And the other cluster is basically that domestic courts reserve the right not to follow the human rights courts if they deem that this would be problematic from a constitutional perspective. So if the constitution or a certain constitutional core stands in the way. And again, here it's important to highlight that, of course, this insistence on limits exists since a long time. An early example is a judgment by the Austrian Constitutional Court from the year 87 already. That clearly shows that this type of constitutional limits has always played a certain role. However, the cases that I analyzed really clearly show a certain trend over the last years and a changing attitude towards the human rights courts, also in established democracies. And in my opinion, really a paradigmatic example here is the Italian Constitutional Court that used to be really very open towards the European Court of Human Rights, and that in 2015 stated that Italian courts were no passive recipients of an interpretive command issued elsewhere in the form of a court ruling. So how to make sense out of this now? I also looked at this in my paper, and at closer look at a first important point seems to me to be at closer look that frictions and tensions seem to increase between the legal orders. However, cases of actual conflict remain really rare. What do I mean with cases of conflict? Cases of conflict are really the cases where the non-compliance of a domestic court leads to non-compliance with the judgment as such, breaching basically the binding force of the judgments. And an example is the Russian Constitutional Court that declares certain court judgments of the European Court of Human Rights to be non-constitutional, with the consequence that they cannot be implemented in Russia altogether. But these cases of hard conflict are really rare, and much more often we see domestic courts rejecting, for example, just a line of jurisprudence of the European Court of Human Rights or the Inter-American Court of Human Rights. And one of the consequences, in my opinion, that we should draw here is that we should not call these cases of hard conflicts. They should not be called judicial dialogue. Many people use the term judicial dialogue for all types of interaction, and in my opinion, we should make a distinction here and call these more conflictual interactions dialectic review, as it has been proposed in the literature, and not judicial dialogue, which is a completely lawful tool. The second important consequence, in my opinion, is that we should not see this trend in the jurisprudence simply as a reflection of an overall nationalist or populist climate. I really think that it is important to look at judicial resistance as something that follows its own logic. And I really think that is, in a way, also a reaction of domestic courts to the massive increase, actually, of international law, of international judgments they see themselves confronted with, which obviously also leads to many tensions with domestic constitutional law, domestic legislation, and domestic courts really, it happens that domestic courts see themselves in the dilemma that they either apply international law violating domestic law or the other way around. And I really think this is something that should be taken into account. And another important aspect, of course, is judicial politics and power games. Domestic courts have used the human rights courts to strengthen their own position. And now that the human rights courts have become powerful players, domestic courts also kind of jealously try to protect, to preserve a space for their own decision making. So in this sense, there is certainly also a certain power game at play here. But the question that arises now, of course, is normatively, how should courts deal with this type of situation? What is a good role for domestic courts at the intersection of international legal orders? And that is what I look at in the last part of the paper. And here the conclusions I draw is that really important normative reasons support the view that domestic courts should take an active role in the implementation of judgments of the two human rights courts. Human rights judgments are no pure interstate issue. This is different, for example, maybe in the case of the ICJ, for example. And to not grant individuals the possibility, basically the avenue to enforce cases in front of domestic courts would also lead to a certain asymmetry between the international and the domestic arena here. And as I have also seen really in the paper, is that in many instances, domestic courts are the only enforcement avenue open to individuals. On the other hand, this should not mean that courts should blindly follow the two human rights courts. So disobedience in rare cases can help to moderate the negative side effects of multilateral governance. Many people, many voices in the literature claim already a certain constitutional right to resistance. And I agree that this form of disobedience can have, in very rare cases, it can have a legitimizing force, and that this type of interaction can have a legitimizing force. International courts, of course, operating in total isolation cannot be legitimate courts. But however, I think the systematic control that we can observe now, that certain courts started to introduce really systematically, checking the judgments of the two human rights courts, whether they meet constitutional standards, and sometimes really based on fixed criteria. In my opinion, this type of systematic control is problematic. So the normative finding in the end is that courts should not be conceptualized as pure compliance partners or as pure gatekeepers. They should be seen basically as mediators between different legal orders with some flexibility. And the conclusion of the paper is that the open and flexible stance courts have taken when engaging with the human rights judgment is better suited to cope with the very complex legal reality that they are faced with nowadays than systematically judging anew on matters that the human rights courts have already decided. And now I'm really curious to hear Alejandro's response from an inter-American perspective.
Thanks, Raffaela. That was really interesting. Alejandro.
Thank you. Please.
I think Raffaela is going to stop sharing her screen, and then you will get a chance to share yours, Alejandro.
Okay.
Great. Thank you.
So we all set? Do you see me, the presentation properly? Oh, thank you so much for having me. Thank you, Professor Regan. Thank you, Raffaela, for your wonderful paper. I'm honored and also very thrilled to be part of this conversation. I'm going to talk precisely about a specific aspect of Raffaela's larger perspective, and in particular, I'm going to center my comments on the Inter-American Court of Human Rights. So I believe Raffaela is right about the fact that we cannot explain everything that's going on between domestic and international human rights courts by reference to a backlash or reference to a nationalist resistance against multilateralism. I think she's right that domestic courts act as mediators, but I also think that we can enrich and complement Raffaela's perspective if we take a bit more in-depth, a bit of a more in-depth look to the literature on judicial politics and how judges decide cases and the specific institutional and political and legal context in which each of these decisions operate. So as I name my presentation, I think we want to put these courts and these judges in particular under the microscope. So in a sense, I'm concerned with these three aspects of the reality as a way to explain or account for what's driving these courts to change their positions towards their international counterparts. So I'm looking at judges' agency, the political context in which they operate, and also the legal culture in which they operate. So I'm going to give 4 different examples about how I think this further way of looking at this reality might illuminate some of what is going on and some of what is driving the court's decisions. Because as I say elsewhere, we see a lot of variations from the same court saying, "Oh, the whole case law of the Inter-American Court of Human Rights is binding upon us, so we are bound to use all its case law," to go and say, "Oh no, we're going to decide which case law is binding and which case is not, and we're going to not comply with even direct orders from the Inter-American Court at some point." And I think it's interesting to see how this big variation operates. So the 4 examples I think might illuminate some of this. So take, for instance, a situation in which a domestic court decides that the whole of the case law of the Inter-American Court of Human Rights is binding upon itself. And one interesting example is the Colombian Constitutional Court, which did that in 2 different periods. The first period, it was as soon as it was created, and one plausible explanation for this is that it was being seriously challenged by the Colombian Supreme Court, which was up to the constitutional reform of the 90s, the highest court of the land. And so when the Constitutional Court was created, the Supreme Court said, "Oh, we're going to challenge the authority because we want to retain our power of the highest court of the land." And the way in which the Constitutional Court reacted was to say, "No, we are bound by the Inter-American Court of Human Rights case law, and we're going to apply all the case law because we don't have a case law on their own." And that sort of was used to stay or to maintain the authority before the Colombian Supreme Court. When that issue was resolved, the Colombian Constitutional Court decided, "Oh, we're going to take the jurisprudence or the case law of the Inter-American Court of Human Rights as a guiding reference for the interpretation of domestic law." But in 2005, again, the Constitutional Court had to, or wanted to, strike down some parts of the Justice and Peace Law. Justice and Peace Law was a law passed by the Uribe administration in Colombia, giving enormous benefits to the paramilitary groups that were going to demobilize. And the Constitutional Court of Colombia wanted to strike down some of those aspects because they entailed outright impunity for several international crimes. And in order to do that, the court resorted again to the binding authority of the Inter-American Court. But there were no cases against Colombia on this particular aspect, so it went with a case against Peru. Again, this was a way to resist the pressures and the threats and the challenges from the Uribe administration, and it used it in self-defense. And again, when this threat or challenge passed, they went again to decide the cases on their own. And similarly, if we look at Mexico, for instance, Mexico decided that the whole case law was binding upon itself at a certain point when a lot of cases were lining up before the Inter-American system because of severe human rights violations taking part there. And Mexico decided after giving sight to the Inter-American system that it would comply generally with the its case law, that they were going to decide on a case-by-case basis which decisions they were going to comply with. And the way in which they did that was by stating that in general, the case law of the Inter-American Court of Human Rights is binding, except when it goes against a clear constitutional restriction. Now, of course, the Mexico Supreme Court was going to decide when the case law of the Inter-American Court faced a domestic constitutional restriction. So, in a sense, they were going to decide when to apply the Constitution of Mexico and when they're going to apply the decisions of the Inter-American Court. And an aspect that is interesting about this particular case is, as Francisca Paul has recently argued, that it has to do with sort of legally ideological fight within the Mexican Supreme Court between the formalist and more conservative judges who are more with applying directly the Mexican Constitution, and the more progressive internationalist judges that were closer or felt closer to. So when the whole court felt threatened by possible hard or harsh judgments by the Inter-American Court, they decided, we're going to comply with the Inter-American Court. And when that threat somewhat passed, this fight between the two factions sort of resurged, and the formalist sort of took the better view or the strongest point. The third situation in which this power or this judicial politics operates in the region is the case that Raffaela mentioned, the Fontevecchia case in Argentina. And it's interesting that in that particular case, after Raffaela said that the Argentine court was a strong partner of the Inter-American Court of Human Rights, and that's absolutely true. But at this point, in 2017, the Supreme Court of Argentina decided to change drastically its jurisprudence and decided we're not going to comply with a specific decision of the Inter-American Court against Argentina. And that was the Fontevecchia case. But interestingly, the court decided not to comply with the less significant part of the Inter-American judgment, which was that they had to declare null and void a previous decision of the court. And they were going to comply with all the implications for the people involved in that judgment, which was a judgment concerning freedom of expression, but they were not going to say that the previous decision was null and void. And interestingly, the Inter-American Court, which was under significant challenges from several actors, particularly Argentina, Brazil, Colombia, Chile, said, okay, we're going to accept this. We're going to accept this challenge, and they accepted the Argentine proposal that there's going to be an asterisk next to the decision of the Argentine Supreme Court, saying that this decision has been reversed by the Inter-American Court of Human Rights without necessarily requiring that it would not nullify that decision. Now, the same court, the Inter-American Court of Human Rights, when it was dealing with other sort of issues in El Salvador and Guatemala, they were taking a much harsher position because they felt, for instance, they ordered Parliament not to treat certain bills. So, and this, I think, differentiated approach has to do with political power and the kind of challenge they felt in one context and the other. And the final case that I decided, or example that I bring to sort of show the way in which this judicial politics and this sensitivity to political and legal context matters is that Chile has a complete different approach to the whole issue. So Chilean Supreme Court was always quite deferential to the decisions of the Inter-American Court of Human Rights regarding Chile. But as Alexander Huneles has recently shown, the Constitutional Court was created, and in fact, it took upon itself to follow a very conservative activism against the Inter-American Court in general and against human rights in general. And that, in a sense, has been completely different from the Colombian, the Argentine, the Mexican case, which in itself shows that we also need to look at particular constitutional histories. And it's interesting that this particular position of the Chilean Constitutional Court and in the Chilean judiciary in general has led to the political crisis we saw in Chile last year and the constitutional reform process that we are seeing today. But interestingly, some actors are using the international law obligations, international human rights obligations as a constraint on this constitutional process rather than as a way of enhancing it and making more open. So to sum up, I think Raffaela's paper is extraordinarily illuminating. I think we can complement that her views with further reading on agency, political context, and historical and legal culture. Thank you so much.
Thanks very much, Alejandro. That was really very interesting. And thanks as well again to you, Raffaela. So we've collected a few questions already, and I'm going to start off with one from my colleague, Martin Scheinen, who would like to hear both your views on the effect or authoritativeness in domestic courts of a finding of a violation of the treaty as a matter of the interpretation of the treaty made by an international court, as distinguished from a pronouncement on the appropriate or recommended remedy. So do you see a difference in the way in which domestic courts are approaching the jurisprudence of international courts in relation to findings about violations as opposed to findings about remedies?
Shall I start, or you want to start, Alejandro? Well, that's a very interesting question and a very good point, I think, and I have indeed found differences. I think, of course, the Inter-American Court is already very known for its very detailed remedies, so the Inter-American Court rarely just finds a violation, and I think this is also one of the strengths of the system. And also the European Court has started really to use more remedies, and it is indeed one of my findings that the domestic courts, the more precise a judgment, of course, is, the more difficult also it becomes to not follow it, to not implement it. Of course, a convention finding just a violation, just stating a violation, leaves also more leeway to the domestic system how to implement the judgment. It can also be seen as a call upon the legislative, for example, to change the situation and less on courts. So in this sense, that's what I meant by the preciseness of a judgment. In my opinion, this preciseness has played a role in the jurisprudence of domestic courts. And importantly, I think also most of the cases I looked at, actually, they did concern remedy decisions. So it was really about cases where individuals then go before domestic courts in order to enforce a judgment, are very often judgments that really issue the concrete remedy, be it on their status, for example, of unconventional court decisions or of unconventional prison sentences. So in this sense, I really think the preciseness does play a role.
Yeah, thank you. Alejandro.
Yes, I think it's a great question, and one I have to think more carefully about. But I think that the Fontevecchia saga sort of gives some, illuminates a bit what I think about this. So I think generally that's easier for domestic courts to not comply with remedy decisions than with violations or findings of violation. And that's precisely what happened in the Fontevecchia decision. So the Argentine Supreme Court, as I said earlier, was much more comfortable saying, "Oh, I'm not going to comply with this particular remedy, although I accept all the findings on the violation." And it chose the thinnest part of the remedy to reject the authoritativeness of the decision of the Inter-American Court. And what I think it's very interesting is that I hadn't seen that before, but this opened a process of negotiation between the Argentina and the Inter-American Court about what kind of replacement for that remedy they were going to find. And Argentina proposed this kind of asterisk notation, and the Inter-American Court accepted it. And so I think that also on the part of the Inter-American Court, there might be a bit more leeway, a bit more flexibility when challenges come in light of what the remedies they have ordered, rather than with a more substantive decision on the violation. But as I said, I think this illuminates an instance of this, but I think I need to think about this more carefully. Thanks.
So if I could just follow up on that, and I wonder to what extent you see kind of doctrinal engagement by the domestic courts with the kind of reasoning that's happening in the international courts and its plausibility or persuasiveness or cogency. Again, you know, in my own experience was only really reviewing, for example, because the African system was pretty much in its infancy until recently, reviewing decisions, for example, of the Human Rights Committee under the ICCPR. But I just wondered whether either textual differences between a domestic constitution and the Inter-American Convention or the European Convention, of course, of which there are many, or kind of quality of reasoning is something that impacts on these decisions to be compliance partners or gatekeepers.
Shall we again go in the same order? Okay, perfect. That's another great question. And I think actually it does play a role. And for example, the Italian Constitutional Court in its 2015 judgment has made that an explicit criterion, basically. So it clearly states that it will look now in the future at how persuasive, how consistent, it talks more about consistency actually, the jurisprudence of the European Court of Human Rights is, because in the opinion of the Italian Constitutional Court, the European Court applies its jurisprudence sometimes very inconsistently. It clearly says that in its judgment. And it will now in the future look at how consistent it is, and also how far this jurisprudence is suited for Italy. And a kind of similar line of jurisprudence also exists from Germany, where also the German Constitutional Court has used, on the one hand, this consistency criterion, but also on the other hand, in how far the jurisprudence applies or is suited to the German legal order. And also, for example, there is an interesting Swiss case where the Swiss Federal Tribunal decided not to follow the European Court of Human Rights because it considered that it overstepped its consequences. And in this case, the court had taken into account facts that had happened after the final Swiss decision, and in this sense, it considered that to be ultra vires and decided not to follow it. So I do think domestic courts really also look at how persuasive or also how legally, doctrinally persuasive judgments are and take that into account.
I will only add two small comments on Raffaela's answer. One is that my sense is that in terms of the doctrine of the Inter-American Court of Human Rights, domestic high courts pick and choose what they need when they need it, particularly when it's not a case against their own country. Having said that, I also think that they have been pushed to take more seriously the doctrines of the Inter-American Court of Human Rights, because parties use that doctrine a lot in arguing before domestic courts. So it is the fact that litigants will resort to doctrinal developments in the Inter-American system. And my sense generally, again, I need to do a bit more detailed research on this to give a more definitive answer. But my sense is that the high courts still pick and choose a lot, and they have still quite a bit of leeway of when they want to incorporate doctrinal developments of the Inter-American system within or in the context of a general acceptance of the human rights framework, because well, in Argentina it has been the American Convention has been incorporated to the Constitution. In Colombia, the courts consider it part of the constitutional bloc. So human rights are part of Latin American's constitution in many countries. But within this context, again, I think high courts pick and choose a lot of what they want to use.
Can I very briefly follow up on this, because I find this is an interesting point, and I agree with you, Alejandro, but I still think that we really need to distinguish between cases where individual litigants want to enforce a very concrete particular judgments and decisions where high courts are just interpreting the jurisprudence at large. I think in cases where individuals really want to enforce a judgment, there is much less leeway for the high courts. And of course, in these cases, the case is very much framed also by what the parties argue, basically. So I agree with you, the high courts, they do pick and choose, but in the cases I looked at particularly, this has been really less the case. And the case is very much framed also by what the litigants bring forward.
Yeah. Yes, go ahead, Alejandro.
I think this conversation is great, and I'm learning so much. So I agree. I think that's a relevant distinction. So my comment was generally about taking doctrinal developments in general and applying them in the particular case. I think that when it's an individual decision concerning the compliance, the application of the courts have much less leeway. However, what I find interesting is that at least the only two empirical research, or the one empirical research I know and the one doctrinal research I know, show that lower courts do not necessarily comply with Inter-American decisions in at least half of the cases. So the situation is a bit, even within the cases which are about the application of decisions by the Inter-American system, there is still quite a bit of resistance or leeway from local courts.
That's also interesting. So I'd like to turn to a question about that is going back to Raffaela's paper in particular, and it's what specific basis would you argue at the end of your paper that systematic control based on fixed criteria by domestic courts would be an appropriate way for domestic courts to mediate, is the language you used, between the international sphere and the domestic sphere. And he says, what much depends on what is meant by systematic control, for presumably one would welcome fixed criteria if they would genuinely allow for an open and constructive dialogue with the court in contexts when it may be reasonably argued that there's a diversity of practice and, for example, a political advertising ban on TV or nuances of fair trial procedures in a common law country within the European example. So, I mean, do you want to comment on that, on what specific basis would systematic control based on fixed criteria kind of work, and explore the idea a little bit more fully? Yes,
so to make that very clear, so in my opinion, fixed criteria are not the good way to go. It's okay. Exactly. I find fixed criteria are just not suited to capture basically this very complex legal reality. And systematic control, that's an excellent question, and this could be elaborated much more. What I mean by systematic control is really the cases that I found where domestic courts started to really develop doctrines, develop case law that allows them to test in every single case whether this fulfills a certain constitutional test, let's say, or basically courts started to develop tests these judgments have to pass in order to be implemented. And these tests are often based on rather fixed criteria. Like, let's, for example, take the Argentinian, the Fontevecchia case, where the court said that inter-American judgments now need to respect the fundamental principles of public law. And this very much reminds me of the test foreign judgments have to pass in order to be enforced in the domestic legal order. Exactly this execution of foreign judgments, and in my opinion, this is not really suited for international court decisions that are binding decisions that had already gone through all the hierarchy that have been before domestic courts and then ultimately before the Human Rights Court. So in my opinion, to again subject them really to a formal test is just not suited, and it makes much more sense. How many domestic courts have done it, by the way, as I also show in the paper, to really decide on a case-by-case basis, to look at if there is a conflict between domestic law and the convention, what is more important in this case? Because of course, courts very often, they are in a dilemma, as I also try to show. They are, of course, on the one hand, bound by their domestic constitution, and on the other hand, they are also bound by human rights law. So there are conflicts, and in my opinion, the better way to deal with these types of conflicts really is some flexibility, and to look at it on a case-by-case basis rather than developing this type of test constitutional threshold. But maybe Alejandro, I would be really curious to hear about the Argentinian case more also.
Well, although this is entirely on your paper, my reaction is sort of similar to what I've been saying. I think that we need to understand that justices are individuals and are human beings, and they don't like to be told what to decide on a particular case. So whatever is stating a very rigid pattern of how they are supposed to decide future cases, they're going to resist that, and so they're going to try to find ways. And the Fontevecchia decision is one that case. So the Argentine court received 2 new judges. Both of them were not particularly keen on the jurisprudence of the court concerning the Inter-American Court of Human Rights decisions binding character over the Argentine Supreme Court, and they found a case where they thought, I believe, the backlash or the reaction of the court would not be so severe that they would have to go back in and restate the previous case law of the Argentine Supreme Court. So they found a particular issue on, I think we can get away with this. But that particular decision, although it created a lot of stir and controversy in the Argentine legal culture, it was clearly a way to show that, okay, but we are not necessarily bound by the Inter-American Court of Human Rights case law, even in cases against Argentina. And I think the more you try to impose fixed criteria or systematic control from the top, the more resistance you will find, and the more domestic courts will try to evade that kind of jurisprudence.
So I understand why Alejandro puts it that way. I mean, at the end of the day, from a doctrinal point of view, don't we need to have something other than on a case-by-case basis, courts will decide whether or not they will follow the jurisprudence? I mean, it may be that there would be a series of considerations that courts would take into account, and particularly depending on what the system would be. If the system basically says you must take into account the jurisprudence, and we're not talking about the individualized case, Raffaela, where the individual complainant is now seeking to enforce a remedy in an international court domestically, but we're just talking about considering the principles that have been developed internationally. Don't we have to have more than a case-by-case basis for clarifying when you could expect to be able to, what the principles would be, whereby a court would decide whether they would find, if you either formulate it as find the jurisprudence compelling or persuasive, or you say that they would implement that jurisprudence? Don't we have to have more than just a case-by-case basis to be kind of a legal system?
Well, in my opinion, in this case, there really should be a great leeway, because the conventions, the European Court has said that very clearly. It is not the only organ interpreting the convention. This is really a common task to it and the domestic courts. And in these cases, I really think there should be a lot of leeway, and the jurisprudence in this sense should really be developed by domestic and the European Court of Human Rights together. So in my opinion, in this constellation, we don't really need criteria. This is really, for me, this is the archetype of judicial dialogue. And for me, their domestic courts can also be very sharp. They can also criticize the court. In this constellation, I really don't find that problematic. There, it is really great to have this exchange, in my opinion. More problematic is the constellation, again, when it's about individual remedies. But this is not your question, as I understand it. And I find also extremely interesting, Alejandro, also coming back to your point from before. I really think that's my view from Europe, that in Latin America, we see a change here over time, and that domestic judges also really become more self-confident in a way. So the Argentinian court has clearly changed, and actually there is also an increasing criticism against the very hierarchical position the Inter-American Court takes. This might have worked for a long time, where the Inter-American Court also adapted this position, I guess, because its vis-à-vis were weak institutions in not very well established democracies. And I think that domestic judges also have a stronger confidence now and think that this is not really fitting anymore to today's reality. So in this sense, I really think also we see this change over time. We don't hear you.
Just to finish on this, the commentators come back with the point and really thinking about the relationship under Section 2 of the United Kingdom Human Rights Act with the European Court of Human Rights, to say again, and it may be that actually our difference is really about what we're thinking about when we say fixed criteria, because he points out that the UK courts have developed an approach which says that generally the courts will expect to follow, but it will be particularly where there's clear and consistent jurisprudence from the European Court of Human Rights. And if there's jurisprudence from the European Court of Human Rights that the UK courts don't like, they may well say it's not clear and consistent, but that's one criterion. And whether you call it a fixed criterion, or I suppose we could debate about it. Another is that the European courts don't misunderstand a principle, a point of principle or law. And finally, that it's not contrary to a fundamental principle of UK law. So I suppose that's what I was trying to say, is that those are principles guiding the circumstances in which the courts will give effect to the jurisprudence of the European Court. And they are principles that have some determinative quality. There will be some grey areas where we can have a debate as to whether they apply or not, but it's not simply a case by case. We don't really have any idea what the court will do here. It'll just be how it feels on the morning. That's a different sort of test. So we kind of, any responses to that?
Alejandro, maybe I let you respond now first.
Okay, I feel weird. I mean, I do a lot of legal philosophy, as some of you might know, but so I feel we are doing the non-normative sort of points. So I think, of course, that the jurisprudence of the Inter-American or the European Court of Human Rights do make a difference in deciding cases. But I think that the relationship is much more dynamic than just as a matter of fact, not as a matter of normative, or not as it should be, but as it is. So I think it weighs on the decision of domestic judges. At the same time, I think that relationship is dynamic. So going also to Raffaela's point about the self-confidence of judges. Of course, judges might become more self-confident, but it will depend on the political situation they're in. So now the Inter-American courts or the Inter-American system is not at a particularly strong point in its impact on its reputation in the continent. So it's easier for courts and judges to be more self-assertive and self-confident. Or, for instance, some people like Francisca Pou has recently argued that, of course, the Mexican court has stated that it has a significant leeway vis-a-vis the Inter-American Court of Human Rights. But since the new president has come to the country, Andrés Manuel López Obrador, and that might create problems for the court, we might expect that the court would embrace more deeply the Inter-American Court case law in order to protect itself from domestic challenges. So again, I think that this situation, as a matter of fact, is very dynamic. But I agree with the questions, and I agree also with Raffaela that on the one hand, the decisions and the interpretations by international human rights courts are a significant point of departure, hold significant weight for domestic judges, but how weighty they are, how much deference they will be afforded depends on many particular contexts. And one last point, many particular issues that change over time, which has to do with the threats, the internal threats, the external threats, the power of, and one last point I want to raise, that when the Argentine court was being considered perhaps too deferential to the Inter-American system, that also weakened its reputation domestically. So in a decision by the Argentine Supreme Court, it said, some of the judges said, we think that the Inter-American Court of Human Rights got this point of law wrong. However, we are bound by it and we're going to comply with it. And that, I think, was damaging for the Argentine Supreme Court and its reputation and its standing domestically. And so that, I think, also helped the new judges say, we're not going to go again through this road.
Yeah, that is interesting. Raffaela, do you want to add anything here? I'm also conscious we have quite a few more questions to get through, but if you'd like to say a few things in response, that would be great.
Yeah, just it's a very intriguing observation, the one with the criteria. Maybe I can just very briefly say that actually originally I tried to write a section in the paper about what would constitute a constructive dialogue between the different courts, and I abandoned it because it was too complicated. But I'm really happy to keep on thinking about this, because in the end I think really what it is all about is, and what these criteria are also about, what domestic courts want in these cases is they want to be heard by their international counterparts. And of course it matters to a great deal how they phrase their points. And of course the more convincing they are, the more consistent they are, the more likely it also that their counterparts basically will hear them and will maybe also adjust to their points.
It comes back to a point I often make, which is that I do think text matters. So how the regional treaties are actually domesticated, as in the UK through the Human Rights Act, may actually impact on exactly how this process works. And I don't think we completely can detach ourselves from the importance of text. I do think in many places, at many times, and one would hope in many places, many times, courts pay serious attention to text. So turning then to another question, which is whether either of you think that the kind of worrying patterns of populism in different parts of the world, and potentially particularly in Europe and Latin America, may deepen amongst the populace perspectives of the role played by the regional courts of human rights. In other words, is this going to, how do you think that the kind of shift to populism in the political sphere may impact on the perceptions of the regional human rights courts?
Well, maybe I can start first. This is, of course, a point also going beyond my paper, I would say. And of course, I think this does play a great role. I mean, I'm from Switzerland originally, and there we have had huge debate also about a possible exit from the European Court of Human Rights. And of course, the conventions, at the end of the day, they are built on a culture of compliance. And when this culture of compliance basically deteriorates, of course, this makes it much harder for these courts to operate. And I think this is really the greatest threat to the courts, in my opinion. They do build on this culture. And at least in Europe, that's very much my opinion. Even for states such as Switzerland and the UK, it does not seem nowadays impossible anymore to imagine themselves to stand outside of the Council of Europe, for example. So I think in this sense, the conventions, they do not have anymore the same normative pool they used to have. And I think this is really ultimately, in my opinion, the greatest danger. And of course, the courts, I speak now more for the European Court, it also tries to counter this. It has developed its Article 18 jurisprudence and so forth, but it has, in my opinion, limited means when this culture of compliance fades away.
Yeah. Alejandro?
Very briefly, I have two observations. First is that the resistance to the Inter-American Court of Human Rights in particular, I think human rights courts in general, has come in Latin America, at least, from both populist and non-populist regimes. So the threat has been, and in fact, the sort of most explicit action against the Inter-American Court of Human Rights, if you take away, if you discount Venezuela's situation, which is just not, I don't think it's a reflection of populism, but something quite different, has been from sort of non-populist, sort of center right-wing governments that united to sort of challenge the Inter-American Court and the Inter-American system on its use of its authority. So that's one part of my answer. The other part of my answer would be that I think that it's also up to human rights courts to assess and move politically in a way that sort of maximizes their impact. And I think they have a lot to, and they've been doing things. So, for instance, the Inter-American Court of Human Rights has been sort of enhancing the dialogue with domestic courts by citing domestic precedents, which was something that it did not before. And I think that that's a way of telling domestic courts, listen, we are together on this. And I think that might again enhance its authority and its impact as a way to resist some of the populist dynamics.
So So another question that's come in is whether you see in the pattern of variation between different domestic courts in their approach to the implementation and application of the jurisprudence of international courts, any relevance of the mode by which judges are appointed in those domestic courts. Do we think that the extent to which, Supreme Court or Constitutional Court judges are appointed directly by, political branches of government, whatever, may impact on how those courts perceive international human rights courts jurisprudence?
That's a great question, and I must very honestly admit that I have not looked into that, but that would really, I'm sure this would be a great research question for another paper, and I think this goes also a little bit in the direction of Alejandro's criticism that he raised at the beginning, that it's of course incredibly important to look at the context in each jurisdiction also in more depth. And I think in Europe, probably this question of election of judges is becoming to be more important at the moment. So yeah, probably great topic for another paper.
Yeah. Alejandro, anything you want to say on appointment of judges?
Yes, very quickly. I think this is an empirical matter that we need to test in a lot of detail. One thing I would say is that the Argentine majority against the Inter-American Court of Human Rights appeared at a time when judges were selected by significant consensus. Argentina's constitution requires a sort of supermajority to select Supreme Court judges. So the two judges that changed the jurisprudence of the court were selected by deep consensus between different parties, and one belonged to each of the majoritarian parties. So, and they were in agreement on this. So I don't know whether there's a direct link between the executive appointing judges and resistance to the Inter-American system. I think it might be that states have a broader consensus on whether they want to agree with or comply with the Inter-American system a lot or not. And I think it's problematic.
Well, thank you. So another question turns from the situation where there's, as it were, disagreement or kind of gatekeeping by domestic courts of international courts, to look at the circumstances in which domestic courts and international courts kind of build a coalition around a particular issue. The example given is the array of courts that stood against the UN Security Council's targeted sanctions system, for example, which you saw in a whole range of courts in Europe, and whether you think that how these emerge, and whether you think it's important that they come from an international court or regional court first and then into domestic courts, and does it, to what extent does it depend on the kind of strength of the relevant courts? So this pattern of a kind of coalition on a human rights issue like targeted sanctions. Any thoughts on that?
Yeah, this is another very intriguing and very interesting question, and I would have to think more about that before to give a good answer. But I think what this shows is that, of course, different courts also have a different importance and different powers. And I think some international courts, of course, like the ECJ in this case, in the sanctions case, in the CADI case, of course, this is a very powerful court. And when the ECJ speaks out on such a matter, of course, I guess this will have a greater power than if just, let's say, the Swiss Federal Tribunal issues a decision on that. I would have to think more about that, but I think this is, of course, a very important matter also.
Yeah.
Similarly, I don't know. I mean, my first hunch would be that there's it's easier. In a way, it's easier for regional courts or international courts to challenge the Security Council authority, and basically because they feel it's their judges there. They feel it's their role essentially, because they're in a better position, in a stronger position. At the same time, and this, my sense is that high courts judges are not particularly interested in international law in general. So I'm not sure how sensitive they are to the authority of the UN Security Council, to be honest. But my sense is that if they haven't decided, this is not because of deference to the Security Council, which is something international lawyers feel it's a much broader, much more important thing than domestic lawyers, I think it is. But because it might be that they don't think it's their role, or it's their place, or their issue to be dealing with. But that's entirely a hunch. That's something we need to again do research on.
Yeah, and of course, one of the things about that, it will depend in a sense where the litigation is brought and who's affected and so on, because you in relation to domestic courts and regional courts, you're going to have somebody who's actually affected by it. So some of that will drive how the response develops. So another question from our head of programs, Alan Mikas, was what you think the impact of strategic litigation and parties' arguments are in shaping the approach of domestic courts, to the extent that parties might argue, for example, that the international human rights law shouldn't be applied or should be applied. And Alejandro has already pointed out that quite often in Latin America, what you're seeing is the parties are finding the jurisprudence of the Inter-American Court, and then are mobilizing that in their cases domestically. So do you want to just comment on the role of both strategic litigation and just generally parties' arguments in influencing how domestic courts approach the jurisprudence of international human rights regional courts?
Yeah, this is another really great question. I think in my paper, it has not played such a great role. It would have been probably an aspect to look into deeper. I think in the inter-American system, strategic litigation plays a role since a longer time, I would say, that in Europe. So yeah, this would be another great aspect. I have already said previously that, of course, it matters to a great deal how parties shape their arguments. But in my research, it was a little bit less relevant because it was really about the enforcement of judgments that were already there. So, but broadly speaking, of course.
Yeah. Oh,
so again, I think strategic litigation has been key in many aspects in terms of what issues are looked at by the inter-American system. So, for instance, it's one of the typical examples that people give. Argentina had many more cases against itself than many countries which have, in general, poorer human rights records. And the reason for that was that the sort of strategic litigation in Argentina was very strong. And so they brought a lot of cases, and that's why we ended up having more cases against the country than other countries. So I think it's critical. It's harder to say what role it plays in terms of domestically, at least in terms of the decisions of the court in Latin America in general, in Argentina in particular, are very opaque. So to give you an example, we presented a petition to the Argentine Supreme Court to ask them for access to the appeals, because we're doing empirical work, and we wanted to see how much impact the appeal made on the arguments that the court made, and those appeals are publicly available. But the court said we are not going to give them to you. So I think there is a strong secrecy, and that domestic courts, particularly in Latin America, are keen on opacity, and so it's very difficult to say whether they have an impact on the final decisions and what the extent of that impact, and what the extent of that impact is.
Yeah. Well, I think we're coming to the end today, so I just really want to thank both of you for a really fascinating presentation, Dr. Kunz, and response, Professor Chetman, and also for your really engaged responses to all the questions. I'd like to thank all the people who've attended today. Really grateful for you all being here and for all the really interesting questions that were put forward. And to say that we're now coming to the end of our academic term in Oxford, but we have two events in the next 10 days or so. One is next on the 17th of March, next week, on treaty making in relation to business and human rights, which is a seminar organized by the Business and Human Rights Network based at the Bonavero. And then on the 23rd of March, to say we have the annual Eric Berendt Media Freedom Lecture, and that's going to be by Damien Tambini, and it's going to be speaking to the argument he makes in his new book, Theory of Media Freedom. So please feel free to join both of those events. And finally, to say that together with UNESCO, the Bonavero will be hosting a massive online open course on freedom of expression from mid-April to mid-May. Registration is now open, and you can register via our website. So have a look at the website if you're interested in that. For those of you who are based in Oxford, I hope that you have something of a break over the vacation, and we look forward to seeing everybody back again at our first discussion group in April, which will be on Tuesday, the 27th of April, and we are very fortunate to be joined by one of our advisory council members, Professor Rodrigo Primni, who's a member of the Committee of Economic, Social and Cultural Rights, and we'll be talking about General Comment 25, which is on the right to science. Very interesting development in international human rights law. So those of you who are interested in international human rights law, do join us then. Finally, just to say thanks again to Raffaela and Alejandro. It's been wonderful to have you. And it does seem to me that the lockdown in coronavirus has made some things possible that were otherwise not possible. And that was to get two of you together to talk about this really interesting paper. And we hope that we'll be able to welcome you back to the Bonavero again sometime soon, and to wish everybody else well. Keep safe and look after yourselves, and hope to see you again before too long. Thanks very much, and bye.
Thank you very much.
Thanks a lot. Bye-bye.